Good afternoon. This is the clerk of the court, and it is 1 p.m. in Washington, D.C. Judge Greenberg, the conference is configured for oral argument this afternoon with recording and live video streaming now up and running.
Very well, you may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable William S. Greenberg presiding. God bless the United States and this honorable court.
Good afternoon. This is Judge Greenberg. I'm joined by my colleagues, Judge Meredith and Judge Laurer, in the matter of Craig-Davidson against the Secretary. Will counsel, beginning with appellant's counsel, enter your appearances, please?
Good afternoon, Your Honor. My name is Tom Stoever with the law firm of Arnold & Porter in Denver, Colorado. I represent the appellant, Sherry Craig-Davidson.
Thank you. Your co-counsel wish to enter his appearance?
Good afternoon, Your Honor. My name is Eliseo, Puig, also the law firm Arnold & Porter here in Denver, Colorado, and I also represent the appellant.
Who is going to argue? Mr. Stoever?
Yes, Judge.
All right, fine. And now we'll hear from the government, please.
Good afternoon, Your Honors. Laurer Jemison, representing the Secretary.
And you're going to be arguing?
Yes, Your Honor.
Thank you. All right. I understand appellant wishes to reserve 10 minutes for rebuttal. Is that correct? All right. We'll proceed. Counsel for the appellant, begin your argument, please.
Thank you, Your Honor. May it please the court, Tom Stoever for the appellant. As the court has correctly identified in its order, we believe the answer to the question of whether Ms. Craig-Davidson has statutory and constitutional standing to appeal and may pursue her appeal on the merits turns on the phrase in Demery at page 438, when a veteran dies during the time permitted to file an appeal. It is our position that phrase must be read in light of relevant precedent and the language of Rule 4 to include any period of equitable tolling that a deceased veteran would have been entitled to before filing their appeal. Based on Henderson, the decision in Checo, and the language of Rule 4, we assert that Ms. Craig-Davidson had 120 days from the date of the death of her husband, Mr. Davidson, on May 23, 2020, to file her notice of appeal. The notice of appeal was in fact filed 30 days after that date on June 22nd, 2020. The VA wants to read this language when a veteran dies during the time permitted to file an appeal to mean that the period is 120 days and nothing more. 120 days from the BVA decision, I should be clear. That stingy reading of Demery ignores the decision in Henderson, the stop clock approach that was applied in Checo, and the language of the relevant rules. Your Honors, even if this case did not fall squarely within the four corners of Demery, which we believe it does, the analytic framework used by the court in Demery would require the same result. Fundamental principles, the court there applied some fundamental principles that should guide this court. First, claims should be decided on their merits. Secondly, the outcome of a case should not be decided by the timing of a veteran's death. And I point the court specifically to the language in Demery found at page 437 that speaks to the inherent inequity that would flow from the timing of substitution rights being tied to the happenstance of the timing of the veteran's death, an inequity that is at odds with what Congress did in enacting Section 5121, capital A. Moreover, the court in Demery pointed to the decision in Henderson. The Demery court stated very clearly that Henderson gives this court the flexibility to forgive late filings. We don't believe this is a late filing, but we do believe that that flexibility is what gave the Demery court the ability to look at whether or not the motion to amend the notice of appeal, which was filed 7 months after the notice of appeal was filed, should relate back to the original notice of appeal
Counsel,
thereby making Ms. I'm sorry, Judge Greenberg.
Yeah, may I, sorry to interrupt, but what is, in your view, the good faith basis for the secretary's position in creating what appears to me to be a no man's land, clearly not intended either by Congress or the Supreme Court in Henderson?
Your Honor,
what is the, obviously I could ask the secretary the same thing, what do you reckon is the good faith basis for the secretary taking this position? This is a serious question. Maybe there is a reason to separate the widow from the veteran, but what is it?
Your Honor, I don't believe there's a good faith basis.
All right.
I mean, being perfectly direct with you, Judge Greenberg, I don't believe there's a good faith basis, and I'm curious to hear what it is, because as I read the opposition brief, the secretary takes the position that the 120 days, in a circumstance like this, the 120 days from the date the BVA decision is issued runs out, regardless of the circumstances that the veteran might find him or herself in. And again, going back to the language in Demery, and this relates back to the language from Breedlove and even in Reeves, this court's decision should not be driven by, and I'll use the word that the court used, happenstance of the timing of the veteran's demise. And we know in this case, we know that Ms. Craig-Davidson is an eligible accrued benefits claimant. The secretary has told us that the VA agrees with that position. So we don't have to get over that hurdle, which was part of Demery. But if we know that, then Ms. Craig-Davidson should stand in the shoes of her husband.
Well, let me ask you this.
Yes,
at the end of the day, if we were to rule in your favor, would the appellant get a sum of money?
If you were to rule in our favor, then we have to brief and argue the merits.
Assuming that the merits of the case are available to you, is there a judgment that's going to be rendered in your favor?
Yes, Your Honor, and that's why that's part of the reason why Ms. Craig-Davidson is an eligible accrued benefits claimant.
Right. So there's no issue here about case or controversy or something like that.
None.
At the end of the day. All right.
That is absolutely right.
So you just want this court to apply the concepts in Henderson, and I would say also in Scarborough by Justice Ginsburg on the EJA kind of case to the facts and circumstances here, and maybe make a broader pronouncement as to what is required from the secretary when faced with facts like this.
If I were, if you're asking me what would I like, Judge, what I would like is a decision that says an eligible accrued benefits claimant like Mrs. Craig-Davidson stands in the shoes of the deceased veteran, and whatever the deceased veteran was entitled to, and we believe that under the circumstances, Mr. Davidson would absolutely be entitled to the benefit of equitable tolling, then Mrs. Craig-Davidson, as an eligible accrued benefits claimant, would receive the same thing.
So in other words, you're asking the court, we have to make a determination, do we not, that the veteran would have been entitled to equitable tolling?
I believe that's true. And I believe that decision is an easy one based on this court's opinions and going all the way back to Erebus. I mean, this is a man who was on his deathbed for almost the entire period of time between the issuance of the the BVA decision on December 3rd and his demise on May 23rd of the following year. As Ms. Craig-Davidson's affidavit submitted to the court makes clear, Mr. Davidson was heavily medicated. He was on palliative care, and the efforts to ease his suffering absolutely affected his ability to communicate, to handle the tasks of daily living, to make deliberate decisions, and to do all of the things which the Erebus decision points to as being sort of the criteria for whether or not equitable tolling should apply. And I would go further to say that Ms. Craig-Davidson acted with incredible due diligence filing the notice of appeal 30 days after her husband passed away, as soon as she found, this piece of mail sitting in a pile, undoubtedly that had been neglected while she was taking care of her dying husband, and has acted with that same level of due diligence every time the court has asked something from her. I'm sure your honors are aware that in October of, I think it was 2020, or 2019, pardon me, the court asked Ms. Craig-Davidson for some materials. She filed it a week later. Every time the court has asked something from her, she has responded quickly. And I would say that, the only argument I can see that the secretary might have with respect to equitable tolling, and I believe the only argument that's allowed under Henderson is that there's some prejudice to the VA, and I don't see any possibility of prejudice to the VA here. As this court is well aware from the decision in Reeves, I mean, the VA's interest here is not in winning the case, it's in doing justice and making sure that the veteran gets every benefit he's entitled to. And here, I don't see any way that there's an argument that somehow the VA's case is prejudiced.
Thank you. Judge Meredith, did you have a question?
I want to ask a preliminary question first. And during the veteran's lifetime, from when the board decision was issued until he passed away, did the appellant have any legal authority or obligation to act on his behalf? Could she have initiated an appeal for him during that time?
I believe the answer to that question is no. Now, if you're asking the question more broadly, Judge Meredith, could she have gone to Mr. Davidson's VSO rep and asked that an appeal be filed? I suppose that's possible, but she certainly, her focus was on taking care of her husband. And so much so, as you can see from the affidavit she filed, that her own health was put at risk. And she had to take medication to deal with the stress and the strain of doing these things. I'm sure it's not lost on anybody here that, when a loved one is dying, everybody is under stress. And so I think that the way the statute reads, the way the case law reads, is if, Mr. Davidson was alive, the appeal had to be filed in his name. That's certainly the implication of Demery. When the Demery opinion talks about the nullity, the fact that the original notice of appeal filed in his name, but after his death was a nullity. So I think the answer to your question is it had to be filed in Mr. Davidson's name, and the circumstances just prevented that from happening.
Okay, thank you. Moving on to the issue of standing, I think you acknowledged initially that under Demery, the question of standing here may turn on whether the veteran's time to appeal had already run when he passed away. And so to the extent that the timing issue is relevant to standing, does the appellant, before establishing standing, can she ask us to toll before she's established standing, or does she have to establish standing and then ask for tolling? In what order do we answer those questions?
Sure. Judge Meredith, if I said that or suggested that, I apologize. I did not mean to. There is no question that Ms. Craig-Davidson has standing. That issue is resolved by virtue of the VA's acknowledgement of her status as an accrued benefits claimant. So she has standing. There is a separate question. Yeah, there is a separate question about whether or not this appeal can move forward based on the timing of the filing of the notice of appeal. Under the law, Ms. Craig-Davidson could dismiss this appeal and go back to the VA and start a whole new claim. That is one avenue that's open to her under the case law and under the statute. That means that she has standing, regardless of what this court decides on the equitable tolling point. Our view is that the language of Demery, which talks about the period for filing an NOA, it doesn't say 120 days. It doesn't specify something more narrow. It just says the period for filing an NOA means the 120 days plus any additional time that would be added on based on the doctrine of equitable tolling. And in this case, we think that means that the period did not begin to run until the extraordinary circumstances stopped. And sadly, that means the point in time when Mr. Davidson passed away, and then it began to run.
As to that issue of tolling, I know you mentioned a couple of cases earlier, but under the Barnett line of cases from the Federal Circuit, in a different context, suggested that mental illness could stop the clock, could toll if that mental illness rendered the veteran incapable of handling his own affairs. So I think you've mentioned this before, but the focus of between the time of the board decision and when the veteran passed away, should our focus be on his capacity during that time, as opposed to what the appellant was going through during that time?
Absolutely, Your Honor. And I'll just use the example I'm most familiar with, and that's the Henderson case, where I was counsel for Mr. Henderson. In the Henderson case, he was incapacitated for a period of time because he was receiving treatment that included a very heavy dosage of medication for a period of time that told the running of the statute. Mrs. Henderson, and he was in a hospital, and this was outside of the pandemic environment and all of the other things. Mrs. Henderson was not so incapacitated, and yet in that case, it was determined that equitable tolling existed. So I think the answer to your question is yes, the focus is on the veteran's capacity, and the clock doesn't begin to run or stops and then doesn't start again until that incapacity is resolved somehow.
So under that, I think you're referring there to the stop clock approach that you suggested we use to tolling. So when the Federal Circuit adopted that as an approach to tolling, they said that not only do you need the extraordinary circumstance that stops the clock, but you also have to show due diligence and causation during that period while there's an extraordinary circumstance. What would be required to satisfy the due diligence requirement in these circumstances? Do you need to show that the veteran could have or did do something during that time, or under the Barnett cases, is it sufficient to show that he may have lacked the capacity or did lack the capacity to handle his own affairs?
Well, I may need to go back and read Checo, but my understanding of the due diligence requirement is not that there be due diligence during the period of incapacity, but rather that the due diligence occur after the incapacity is over. So the incapacity, if
I could, before you go on, I just read you the language from
Sure.
Checo, talking about if there's the stop clock approach is used, then you'd have to show due diligence during that time of when the extraordinary circumstance had stopped the clock, and that you have to show causation during that period as well. But my question is, how do you do that if the veteran is the focus and the veteran's incapacitated? Is that enough? Does that satisfy or obviate the need to look at the due diligence requirement during that time?
Right. Well, I would point to Erebus and say, yes, it does. If the veteran is incapable of managing his daily affairs, I think by definition, there is no way that the veteran can show due diligence. And I think, again, I would point to, what Ms. Craig-Davidson did following very shortly after her husband's passing. She moved very quickly to make sure that her rights as Mr. Davidson's surviving spouse were protected. So I think that, again, in my experience working on cases like these, that's a level of due diligence that is rarely seen, rarely demonstrated by an appellant.
I just have one last question. To the extent that we're focusing on the veteran's capacity during that period from the board decision till his death, do you believe that we already have sufficient evidence in what's been filed so far to demonstrate that? The declarations filed by the appellant? Absolutely.
And as far as I'm aware, no one has questioned the information that's been provided. I don't think the VA has, in fact, I believe the VA acknowledged the very, difficult circumstances under which both Mr. Davidson and Ms. Craig-Davidson were having to survive at the end of 2019 and through the first quarter of 2020.
Thank you.
Judge Laurer, any questions?
Thank you, Judge Greenberg. Mr. Stoever, what is your view of the holding in Demery that an accrued benefits claimant has standing to file an appeal after the veteran's passing, quote, during the time permitted to file an NOA? In other words, does the specific language from Demery refer only to the time permitted under Section 7266A?
The answer to that question is two questions, so let me break it down a little bit. No, it does not refer to the 120 days in the claims processing rule that's embodied in 7266A. What the court, it is our view, and we assert that what the court in Demery meant by using that phrase, the time permitted to file an NOA, is that 120-day period plus any additional time that would be available to the veteran as the result of equitable tolling. If the court had wanted to say 120 days, it could have said 120 days. If the court had wanted to specifically refer to 7266A, the court could have done that, but it didn't. Again, the Demery court was very clear at the end of the opinion. It pointed to the Henderson decision and it said, look, the United States Supreme Court has told us this is a claims processing rule that gives us the flexibility, us, the Court of Appeals for Veterans Claims, the flexibility to interpret these rules in such a way as to allow claims to go forward on their merits, which is the fundamental principle that underlies the judicial system in the United States. And I see that my time has run out, and unless there's anything further, I will.
No, finish your answer and then we'll.
Judge Greenberg, I was done, and I don't want to bore anybody with anything more on that. And I've got some time for rebuttal, so I'll turn it over. Thank you, Judge.
Judge Laurer, though, are you content with the answer? And if you need to pursue it further, we can do that on rebuttal.
Thank you, Judge Greenberg. That satisfactorily answered my question.
All right. Thanks very much. Appreciate it. We'll hear from counsel for the secretary.
Good afternoon, Your Honors. May it please the court. As you discussed, this is primarily an issue of standing, specifically whether the appellant has the standing to initiate an appeal before this court in furtherance of the veteran's claim. Generally, the party initiating the court action has the burden of establishing standing. And in this instance, our position is that the appellant cannot do so because she does not satisfy the statutory requirements of 7266. And for that reason, this appeal should be dismissed. Pursuant to 7266, a person adversely affected by a final board decision must file a notice of appeal within 120 days after the mailing of that decision to obtain review by this court. Here, the board decision that appellant seeks to appeal was issued on December 3rd, 2019. The NOA was due to be filed on or before April 1st, 2020. However, unfortunately, the veteran, Mr. Davidson, passed away on May 23rd, 2020, and the NOA was not filed until June 22nd, 2020. Although appellant argues that you should view the Demery case in a vacuum separate and apart from 7266, it does not appear that that was the intention of the court in that decision. Specifically because the Demery court held that although an eligible accrued benefits claimant qualifies as a person adversely affected by a final board decision under 7266, and acknowledged that they have sufficient injury to support both statutory and constitutional standing to file an appeal on his or her own behalf when a veteran dies during the time permitted to file the NOA. The Demery court also went on to say that that right arises upon the death of the veteran. Thus, it's clear that the Demery court considered all of the things to some degree that we're discussing today and determined that the outcome of that case applies only when a veteran dies during the time permitted to file an NOA. Here, Mr. Davidson died during the 120-day statutory time frame in which he was allowed to file the NOA. And so applying the court's reasoning in Demery, Appellant does not satisfy the effects of 7266. She did not become a person adversely affected by the board's decision until, with the right to pursue her own appeal, until after her husband's death, which was again after the expiration permitted to file a timely NOA. So to that extent, Demery, the holding in Demery does not apply here. It is dispositive because when you apply the analysis that the court did in Demery, it is clear that the court did consider and they did make specific findings as to when a party becomes an adverse party such that they can file a claim on their own. Further, this is not a case where substitution should be permitted by law. Substitution is permitted for an accrued beneficiary to step into the shoes of the veteran to complete a pending or ongoing claim or appeal before the agency or the court. It wasn't intended for that party to initiate litigation on the part of a deceased veteran after the expiration of time for which the veteran themselves could have initiated such litigation. Moreover, while the court has adopted an analogous process to 5121A, which governs substitution before the agency, the court has also made it clear that there's only two instances at this point under which they would accept substitution. And that is such as in Breedlove, where the NOA was already filed with the court and the veteran died, or such as in Demery, where the veteran died during the 120-day statutory period. But the facts of this case do not lend themselves to either scenario, and you cannot substitute for someone that's alive. There's, in Appellant's discussion in response to, I believe it was Judge Greenberg's question, as far as stepping into the shoes of the veteran, you can't, the analysis in Demery is very clear that you cannot step into the veteran's shoes, and Appellant would not become, although she's an eligible accrued beneficiary, she would not become a person who is adversely affected by the board's decision until after the death of the veteran. To the extent that Appellant is suggesting that equitable tolling should be applied, that's not for application here either. To be perfectly honest, in line with the question that Judge Meredith asked, addressing equitable tolling before standing kind of puts the cart before the horse. The 120 days period that is discussed in all of the case law to afford a party the right to equitably toll is always referencing circumstances precluding the timely filing of an NOA. In this particular instance, Appellant was never in a position where she could have filed a timely NOA. Again, because she did not become an adverse party until after the death of Mr. Craig-Davidson. So to the extent that Appellant suggests that that language is not dispositive and that the 120 days should be expanded beyond the scope of 7266, the case law is consistent that the only expansion that's allowed with that is equitable tolling. And here, because it doesn't apply, Appellant's claim should be dismissed.
Judge Meredith, you have any questions?
I do have questions. So I want to start where I did with the appellant's counselor. Does VA have a position on whether or not the appellant had any legal obligation or legal authority to file this appeal, initiate an appeal on behalf of the veteran while he was still alive?
Well, Your Honor, she technically would not have been able to initiate the appeal unless she had some other type of authority to act on his behalf, such as like a power of attorney or some sort of something that gave her legal right to act on his behalf. In theory, I believe that counsel does admit, like, she could have also, he was represented by DAV below. His representative could have filed on his behalf. However, although they were married, they are separate people. But I would say that generally she could probably have acted on his behalf if she had some basis or authority to do so within the confines of their relationship, or if there was a power of attorney or some such.
But you're not aware of
authority.
that.
But I am not aware that there has been any such document filed with VA at all.
So moving on to the issue of equitable tolling, in your response to our June 2021 order and just now, I didn't see any or hear any argument that there were not extraordinary circumstances here. It seems to be a legal argument about standing and the timing of who can argue for tolling. Should we, if we were to find that the appellant does have standing, should we consider VA to have waived any objection to the application of equitable tolling here?
No, the court would be required to perform the analysis to determine whether equitable tolling applies based on the evidence that appellant has provided. Our position on that, of course, is that we would defer to the court because ultimately it is the court's decision. However, I will take the moment to respond to whether or not we believe that it should. And the answer to that is no, for the reason of, even if the court was able to determine that there were extraordinary circumstances in this entire fact pattern, we don't believe that the appellant has demonstrated that the extraordinary circumstances are hers. To the extent that the veteran was very ill and unfortunately passed away, his illness is his extraordinary circumstance, not hers. If the court was looking at what her extraordinary circumstance was, that, and I'm of course operating in the scenario under which Mr. Stoever presented, if the explanation is, well, she was taking care of him, those two things don't exist on the same plane in the respect of, because she did not have a vested interest in the claim until after he died, then the time period that you're looking at, the time period you would presumably be looking at would be after he died.
So going back to the conversation I was having with the appellant's counsel, if we were going to look under Barrett or lines of cases similar as to whether, assuming Demery applies in the way that you said it, that the way that you're saying it does, and that the appellant has to show that the time for the veteran to file had not yet expired when he passed away, then if we look at, was the veteran himself incapable of handling his affairs during that period, on what grounds would VA suggest that there wasn't an extraordinary circumstance during that time between the board decision and when he passed away?
We're not suggesting that they would not have been.
You'd even called this those circumstances compelling and that they might establish a basis for equitable tolling.
However, if you separate them out, if you're looking at his circumstance, absolutely. The case law is very clear that for mental, and they're the cases that a counsel cited to, as far as looking at the issues that were suffered by the veteran, as far as physical or mental disability or infirmity that prevented the veteran from filing a timely NOA. Those are unique circumstances to him. However, those circumstances do not necessarily apply to the appellant. That would be for the court to determine. However, if we are looking at, and they are compelling for him, because again, he was not
compelling for him, why would his time period have run? If there were compelling circumstances suggesting that the veteran could not have handled his own affairs in the period between the board issuing the decision and his death, why would we find that the period had run at the time that the baton was passed to his wife to have standing as to this board decision?
Because the problem still remains that on the flip side of that, if you then go to the issue of due diligence, as counsel just suggested, he indicated that she was taking care of him. She was the person that was taking care of all of the household things. The board decision came in December, and the NOA was filed 6 months later. So she also would still have to address how she exercised due diligence, because essentially, by counsel's statement, if we're saying that the mail was not even opened until June, that doesn't necessarily exercise due diligence. I know that, that's not the most sympathetic way to address it, but honestly, I literally just answered your question. But she would still have to get past the hurdle of addressing due diligence, and that the causation of his illness or her taking care of him, whichever one that you're looking at as far as the extraordinary circumstances, is what prevented her from being able to file a timely NOA.
So if I could back up, even assuming the court were to find that during the period between the board decision and when the veteran passed away, that he was incapable of handling his own affairs, and he wouldn't have been able to file an appeal during that time. He died after the 120 days, at which point perhaps the appellant had standing, but you're saying she's too late. So what recourse is it that VA thinks this appellant had? If the veteran couldn't have appealed during his lifetime, and you're saying she can't appeal after he dies, neither one of them had recourse.
Unfortunately, barring some other type of mechanism in which she had the authority to file on his behalf, which at this point there is none known to us, she would not have had any recourse.
My last question then goes back to the Barrett line of cases, and was referenced by the appellant's counsel earlier, that in the equitable tolling case, VA's obligation is not to try to win, but to try to seek justice. So what has VA explored any options for providing the appellant with an opportunity to have her case heard on the merits?
Well, Your Honor, the answer to that is no. At some point, as appellant's counsel did note, she did have recourse. I mean, in this particular instance, the claim that is the subject of this board decision would have also been, there is the option of having filed for DIC benefits. There is the option of, and again, she's an eligible accrued beneficiary, but she's not been determined an actual accrued beneficiary because there was no benefits to get at the time at which she's filed. But she clearly has the option of filing for DIC benefits because in alleging service connection for cause of death. The subject matter of the board decision that is before the court right now is service connection for lung cancer, and that is unfortunately what the veteran died from. So that would be an avenue of recourse for her. The only difference, of course, might be the effective date, but that is an avenue in which she could seek relief. The unfortunate timing of everything in this case, of course, does not go unnoticed, and we recognize that the facts here are sympathetic, but we are also mindful that they arise under a system created by Congress, and that, the court has to operate in a way that addresses the issues for every veteran and claimant rather than just being specific to this case.
Judge Greenberg, anything further?
Judge Laurer, any questions?
No, thank you, Judge Greenberg.
All right. Thank you very much, counsel. Is there anything you'd like to add You were in the process of answering Judge Meredith's questions, and I'm sure she didn't mean to interrupt your argument. If there's something more you'd like to give the court.
Nope. I would just like to remind the court that at this point, Demery is the marker for cases regarding standing. And unfortunately, this court does not, this case does not fall within the scope of Demery. So our position is that because the court's analysis in Demery is dispositive, appellant does not have standing under 7266. And the court should not seek to expand the 120-day statutory period in the way in which appellant's counsel is suggesting today. And the court and the secretary respectfully ask that the court dismiss the June 2020 notice of appeal.
Thank you very much. Appreciate your argument. All right, we'll turn now to, sorry, had you concluded? Yes.
Yes, thank you.
Thank you. Mr. Stoever.
Thank you, Judge Greenberg. Just a few things to follow up on. First, if the secretary's reading of Demery is correct, and if the court follows the path suggested by the secretary here today, it would run afoul of at least two very important points in Demery. The first is Demery points to the decision in Breedlove regarding this zone of no substitution. And basically what the secretary's argument is if a veteran dies after the 120-day period runs, regardless of whether equitable tolling applies or not, there is no one, not a surviving spouse, not a child, not anyone, who can come along afterwards and pursue that veteran's claim, at least pursue it to the point where a decision is made on its merits. That is absolutely anathema to this notion of a zone of no substitution, which the Demery court, followed pretty closely. That began in the Breedlove decision, as the court is aware, and Demery pointed to it and based their decision on it. The second thing is the secretary's argument turns on the timing of the veteran's death and the notion that an accrued benefits claimant's claim should be determined on, and again, I'm going to use the language of the opinion, the happenstance of the timing of the veteran's death was clearly rejected by the court in Demery. It's important to remember that in the Demery decision, they were dealing with a notice of appeal that was filed in a dead veteran's name and deciding whether or not that was enough to toll the running of the 120 days. And then whether Mrs. Demery could act as an accrued benefits claimant, had standing, and ultimately whether her motion to amend the notice of appeal could relate back 7 months back to the original notice of appeal. In Demery, the court was very comfortable saying, look, even though this notice of appeal was filed in the dead veteran's name, we are going to treat it as a legitimate notice of appeal that the amendment could relate back to. And they did that because they did not want to create this zone of no substitution, because they did not want to have a veteran's claim turn on the happenstance of the veteran's death, because they recognize that Henderson gives this court the flexibility that it needs to allow for equitable tolling and to allow an accrued benefits claimant like Ms. Craig-Davidson to pursue her claim on its merits. I do want to turn back to something that Judge Meredith asked me, and I felt my answer was inadequate. That relates to the Checo decision. And Judge Meredith, thank you very much. You are absolutely right about that due diligence component. I would argue that the facts of Checo are a little bit different from the facts here. Checo, as you'll recall, was a case where the veteran was left homeless for a period of time. And there was a question about whether or not she could, get her mail via general delivery and find some other way to be in communication with the BVA. That is certainly not the facts of this case. The facts of this case are pretty clear. Mr. Davidson was on palliative care, was heavily medicated, was unable to care for himself, had to rely on Ms. Craig-Davidson. Ms. Craig-Davidson was working very hard to care for her dying husband, having to do that through a pandemic when she was not able to get in-home help, when she was not able to, make doctor's appointments on a regular basis, just kind of show up in an emergency room or do any of those things. And that put her health at great risk. And she was forced to take medication to deal with the stress and anxiety of that very difficult period. So I would say that those circumstances distinguish Checo only in the sense that there really was no way to show due diligence as it relates to this appeal during the period of time after the BVA decision was issued on December 3rd and Mr. Davidson's passing on the 23rd of May. And then the last point I have really just goes to this whole question of what 7266 requires. 7266 clearly says 120 days, but we all know now by virtue of a long line of cases that 120 days is a claims processing rule. It is not jurisdictional. It does not limit this court's jurisdiction. It merely provides a standard by which the court should process claims, and it is certainly subject to equitable tolling. That was made very clear when the court rewrote its rules and enshrined that concept in Rule 4. And given those things, I don't think there's any question that equitable tolling should apply here, and that the 7266 does not limit the period of time to the period of 120 days when Mr. Davidson was still alive. And just as a sub point to that, I would also say the secretary has argued here that Ms. Craig-Davidson could not have filed an appeal while Mr. Davidson was still alive. If that's true, then her circumstances, whatever they were, should not bear on whether or not equitable tolling applies. So even though she was not the one who was dying, was only the person who was caring for the dying spouse, that should not factor into whether or not equitable tolling applies. Judge Greenberg, that's all I have. I'm happy to answer any questions.
Thanks very much. Judge Meredith? Anything for counsel?
No, thank you.
Judge Laurer?
No further questions. Thank you.
Well, thank you very much. Counsel for both parties have done an excellent job, I might say, on behalf of the court in your written submissions and in the argument today. And we'll consider the matter submitted. Thank you.
And the court is in recess.
Thank you all very much. It was a pleasure to see everyone. Stay well.
Bye-bye.